So then the question is, if you've shortened the patents, what's the next point on which you want to do? And I think, in effect, that not only do you want to secure the transferability rules, you also want to secure the exclusivity rules. I think that Daniel's suggestion that you use compulsory licenses on a model of the efficient breach of contract theory is one of the colossal blunders that we could possibly make. And the first point I would like to say is I spent a lot of time doing contract law, and the only thing that you could say on behalf of the efficient breach theory as a matter of contract law is, in fact, its name. When you actually look at the way in which these markets work, the one thing that is sure to lead to an inefficient system of contracting is to make every contract into an option to basically cancel out upon the willingness to pay damages. What that then does is to force people to measure expectation damages, and we cannot do that particularly well in complicated systems because of a whole variety of problems. Many times you can't figure out what are the direct and indirect consequences of a breach, so the speculative damage rule will undercut the ability to get expectation damages. In addition, you start allowing voluntary breaches, it cascades, because the guy who in turn is a victim of a breach is down on a chain of production. Now he can't honor his contract to the guy below him and so on down the line, so that what you do is you get an absolute total nightmare. There is no question that when you are dealing with the contract situation, rules that allow for injunctions against doing business with third parties, rules that allow for specific performance have been a long-term part of the system. They are really an exceedingly important part of the way in which this thing operates, and the people who start talking about this as a theory of efficiency don't understand. Lisa Bernstein, when she saw what happened to people who quote-unquote sold out goods from underneath other people under an efficient theory, what the trade associations did is they expelled them. This is hardly an effort to show that these contracts turn out to be efficient. And this is exactly the same thing that you get when you go into the intellectual property law. We start talking about valuations. We don't know how to make these evaluations, and it's not likely that we're going to be able to figure out how to do so anytime soon. When they try to use a compulsory licensing system with respect to copyrights and so forth through the public media, they always seem to get the numbers wrong, and that's going to happen here. And what happens also is you get other losses. If you want to enter an agreement with a single exclusive licensee, and then you're going to start having information sharing and so forth, and some other guy can simply breach the contract and come on in, you can't create a system of exclusive licenses, which is an enormously strong benefit. So once you have a world in which it turns out that you limit the duration of the patent, to go and to say that injunctions are never going to be allowed seems to me to be a clear case of political, intellectual, and economic stupidity, or error at least, and that this is true whether you think of patents as being part of a participatory democratic process or anything else. So the basic lesson that I want to leave you with is that we should not come and think of intellectual property as though it's some novel thing from out of space. We should recognize that on exclusion and transfers, the rules for physical property work well, so long as we are sensitive to the duration issues. That's my program. My time is up. Thank you.
Flash eye, a little bit too early. I've had the great pleasure of traveling the country the last couple of years and debating patent policy with Richard and especially with Scott. And over the course of the year, I've come to think of these guys as the Harlem Globetrotters of patent policy. And so I don't think I can match their razzle-dazzle. And bad news for you, Dan, you've just been drafted to the Washington Generals. I don't know if we've ever won a game, but I do think that I can make some fundamentally sound arguments as an economist, and that's what I'd like to share with you. And so that's why I'm going to trouble you to take a look at some slides. First point that I want to make, Richard has alluded to some extent, is that a reason that we have a problem with our patent system today is that it's not performing in many sectors the way that it does in the pharmaceutical sector. So we've got perhaps a story of two different patent systems. In pharmaceuticals, we have a system that performs pretty well as property. And so I list over here considerations that seem important when we want to ask the question, is are patents performing like property? So in pharma, it's possible to search and read other people's patents and to set your research agenda or to license in their patents to further your research agenda. There are high value, their patents are of high value. There's a low frequency of litigation on a per patent basis. And there's a small number of patents per invention. And the technology tends to be discrete, so that there are a relatively small number of inventions per product that reaches the marketplace. Patents are not performing very well in most sectors of the economy, especially in information and communication technologies, because all of the things I just said are good about the way patents perform for pharmaceuticals fail when it comes to information and communication technologies. We have very little search done to see whether or not there are any patents that my new product might infringe. The reason there's very little search is because it makes no sense at all economically. It's too difficult to find all the relevant patents. In some product spaces, there honestly may be as many as 10,000 patents that could read on your product. And when you ask the lawyers, what do these patents mean, they can't give you a good answer. They can't tell you whether you are inside the bounds of the property right or outside the bounds of the property right. And you can scan through the rest of the list, and what I hope you can conclude is that patents do not perform very well as property for information and communication technologies because patents do not communicate effective boundary information. Second thing that I want you to take away from my talk is that we've got to worry very much about enormous rent-seeking costs associated with lawyers who have set up a flourishing business in Marshall, Texas, and elsewhere throughout the country. So people that are concerned generally about the plaintiff's bar should apply with gusto those sorts of concerns to the patent bar. The first thing that I want to draw your attention to is an explosion of patent litigation that's occurred in recent years. So we're looking here at the number of patent lawsuits that are filed annually in federal district courts. And you can see the number basically has tripled in recent years. There's a positive spin that you might put on this. The positive spin is that the number of patent lawsuits has shot up as the number of patents in force has shot up. So an optimist would say that, well, this is merely an unfortunate byproduct of a flourishing and innovative economy. But I think that's wrong. I think that what we really want to figure out is what is the cost of notice failure per innovation. And we could look at patent lawsuits as giving us a measure of the cost of notice failure, but the denominator, that's what we've got to think about. And is the right denominator the number of patents in force? No. It's the amount of innovation, and a better way of measuring the amount of innovation, I think, is the amount of R&D investment, not the number of patents in force. And when we take a look at that sort of measure, we see a 70% increase in the number of patent lawsuits from 1987 to 1999, and it's grown worse over the current decade. There's another strategy that I use in the book that Mark mentioned. It's a strategy of counting up the private benefit of the patent system to innovators and the private costs to innovators of the patent system, doing a kind of accounting across industries to see whether or not the patent system is providing a subsidy. The bottom line that is discussed extensively in the book is that the patent system encourages innovation in chem pharma by delivering a subsidy, as we expect and as we think the patent system should, but the patent system discourages innovation in other industries by taxing innovators. I'll tell you a bit more about what I mean by taxing innovators with the help of these two diagrams. So the first one sorts out the chem and pharma industries, and it looks at, my laser is not